This is the second half of section 14. We're talking about constructive trusts, resulting trusts, declaratory judgments, and ecclesiastical courts. Next Tuesday will be the final class that we have in this room, because next Thursday the Supreme Court is here and they want to talk to all of you about pro bono efforts and things that you should do as you think about both in law school and then as you graduate. So that's from 4 to 6 in room 208 next Thursday. I think pro bono in your career in public service is an important part of your law school career, and I think it ties to the things that we've talked about in part of this class. So next Thursday, 4 to 6, 208, both for, and we'll try and tape it for those that can't be here because they're in online classes, but the Supreme Court has specifically asked to come in and talk a little bit about encouraging, to a greater extent, pro bono and public service efforts with you. So that's what we're going to do next Thursday. So all the cases that we're going to do will be, for the last section will be done next Tuesday. When we last left this discussion, we were talking about constructive trust. Then we looked a little bit, as we finished the discussion, about resulting trusts. And there is a difference. They are two trusts that are created by operation of law. They're not trusts in the sense of a will and trust where someone actually formally declares what their intent is to hold that property on behalf of someone else. But as we see in these cases, there are different ways in which that can be accomplished. Fortin versus Roman Catholic Bishop of Worcester also adds in this other dimension about ecclesiastical controversy. And I think it's important to start to think about it because we tend to focus, have focused, certainly in this class and likely in your other classes, when we think about courts, we think about the civil courts, whether it's a piece of litigation for money or whether it's a family law matter, or we're usually talking about state courts versus federal courts, but there are all of these other courts out there that deal with various matters. And it's not just that deal with various matters, but in certain circumstances, the civil courts will be prohibited from hearing certain cases because they do not have what's known as subject matter jurisdiction over many of these controversies. The other area where this comes in to play is, for instance, in certain Indian reservations and the like. For those of you that have been down to Foxwoods, and something happens there, the likelihood of the Connecticut's courts having any ability to resolve that controversy is pretty low because the tribe is considered a sovereign nation, and they also have their own method of internal dispute resolution similar to this, so that you also would have to be somewhat concerned about how any such dispute would be resolved. But let's talk about Fortin versus Roman Catholic Bishop of Worcester. Actually, before we talk about that, I'm going to ask you about a problem I had and just see what you think. Our church wanted to build a new wing to it, and so they asked people to pledge more money. And they said, you know, over and above what you generally do, if you give us $1,000 extra a year for the next 3 years, we're going to expand it so that we can all go to church at the same time and have a bigger community. So we pledged the 1,000, gave them the 1,000 over the next 3 years, and then they said, you know, we changed our mind. We're going to use it to defray some of our other expenses, and we're going to use it to help pay off some of this litigation bill from the sex abuse scandal and the like. So thanks for the money, but we're not going to be able to do what we thought. So I'm wondering if we have a suit, or if you have a suit that you can represent me on, because I'd like my $3 grand back. I mean,
Good luck.
well, if someone came and said, I will paint your house, give me $3 grand, and they don't, I assume you would take that suit, probably add a 93A count in for fraudulent and deceptive practices, and we'd be right off to court, would we?
Well, is that considered some type of contract?
Say what?
Is that considered some type of contract?
Well,
gave them charity.
I don't know, you're my lawyer. I gave what?
Contract was a long time ago.
It wasn't that long ago. Is it a contract? I mean, what, you guys are the lawyers, you tell me.
It's an oral contract.
It's an oral contract, so we got a contract.
You get a contract.
So what's the deal? I mean, we going to court? You going to court on my behalf? John shakes his head, no.
You go into their court.
I'm going
You go
to,
to the tribunal.
I'm going to some type of ecclesiastical court.
Right.
Well, you're going.
Not
See?
necessarily.
Oh, you're not necessarily going there?
You're not necessarily going to the, you could argue not going to the ecclesiastical court because it doesn't really have anything to do with the religion aspect. Although they could argue it does because they're using it to pay off the case, which was...
Well, not just even the case. Suppose I don't want the case to muddy the waters. They're paying off other expenses that they've incurred, one of which, let's be realistic, would be these expenses. This was a pretty significant resolution. So,
Right. But it also failed like this, which I'm assuming you're analogizing it to this case to Fort, right?
I'm just starting.
Right. So they were able to, the court, the church got summary judgment. There wasn't a case, and they would probably get it in your case as well. Because
So they get to keep my $3,000.
they do. Even though you would argue that, you know, you had a contract, they could raise the statute of fraud, the statute of frauds. There's no, you know, we're talking about, it was to build something.
Yep.
We're talking about real estate again. And it wasn't going to be completed within a year. So the contract, you know, that we've got that issue in there as well, right?
Yeah.
So you'd probably lose. So I would,
So if we're going to lose, then you guys aren't even going to be filing suit for me?
well, we'll do whatever you want.
Well, you will. I mean, I thought Rule 11, you have to, before you can just go forward, you don't do whatever I want.
Well,
Didn't we have that discussion earlier? I mean, you can't, right, you don't do whatever.
well, we would explain to you the consequences and the likelihood of success.
Okay, but so you tell me, and you don't think we're going to win, I say, no, do it anyway. And you do it? Or is it, you don't think we're going to win, or I don't think you have any chance of winning, but if you give me enough money, I'll do it anyway?
Well, there's always a chance.
Okay, so that's what it is? There's always a chance? Go ahead.
I've worked at like theaters and museums and stuff, and people give donations and they'll specifically give it for something. And if that money isn't used for that reason, then a lot of people like would complain, and they're very careful about it. And if it isn't used for that specific person or the purpose, then they'll give the money back. So I don't know how it relates to that.
Sometimes, exactly, I think if it's specifically earmarked and it's not going to be used, then you do have to, and there are some large suits like that where they say, listen, I forget, it was one of the hospitals is my recollection, and I'm not sure it was here, but it said, we gave you $10 million to build a wing, and you know, my wife's name or whoever's name it was, and then they wouldn't do it. They said, well, I want my $10 million back. I mean, but $10 million to someone else, I'd like my $3,000 back. So is it a church matter or not? Because if it's a church matter, that means we can't go to court. And I'll tell you, in the sex abuse cases, there was the argument that it was a church matter and therefore the civil court shouldn't be resolving that. Even for the claims for the personal injuries, it was alleged. First Amendment argument was alleged that, and on first blush it sounds outrageous, but then if the argument on the negligence and the liability flows from the assignment of priests within the parish and within a community, well, one thing is that rests at the core of the bishop or whoever the heck it is that assigns priests. But partly the argument on negligence is, well, you knew what he did and you still assigned him to another parish, right? But assignment of priests is sort of a core thing that we are able to do and should be able to do without interference. In this case, there's an argument for negligence. The other part of it, on the First Amendment claim in that case, which again sounds far-fetched, or at least the claim sounds it without the application, was that, well, an essential core belief is that if you confess what you did, ask for forgiveness, and don't promise not to do it again, then we move on, and that's the way that religion works. So the priest promises not to do it again, and professes to understand how bad it was. Well, then you sort of start over with a clean slate. That's their argument, is that, well, you civil courts shouldn't be touching this. How the church spends its money, whether it decides to build a new wing or close a church, I mean, those would all seem to be pretty core matters within the church's authority.
Yeah, but when you go into a religion, you don't expect to be molested.
Agreed, but do I expect to be ripped off for $3 grand?
Well, it's, I don't.
That's the way they do it, though. That's the policy of the church. They do it during the ceremony, you know. And
Okay, but so
that's the way it goes. That's the policy.
so that's okay though? I mean, or do we have a suit? If this was some one of these guys who travels by truck and comes into my yard and says, "We'll do your driveway over," and they take my $3 grand, and they throw a little tire on it and skedaddle out, we'd say, "Well, that's out and out fraud," and we would be suing them. We'd be trying to have them arrested. I saw someone did that to some poor old guy and took him for 90 grand, and they arrested him.
From what I understand, you're saying that because you're a part of this religion, this is the way we do things. But when you become part, like
Wait, what do you mean? This is what we?
like you're saying, it should be the priest should be able to proclaim that he'll never do it again if he's sorry. And
Oh, okay. That's on the sex abuse stuff, right?
yeah.
I'm just advancing their argument that they used against the plaintiffs in that case, so that you understand
Okay.
that even in that situation, which wouldn't have appeared really expected to me, representing plaintiffs in those cases, is that they were prepared to play that card out and take it all the way to the Supreme Court to see if they could, because obviously they were trying to avoid hundreds of millions of dollars in damages in those cases. And as crazy as it sounds, and I think it's crazy as it, at the end of the day it likely is, there are some core pieces that would tie to the argument on First Amendment. I'm not suggesting that that's part of the religion, as whoever suggested, or you suggested, molestation is what we buy into here.
If they're saying, okay, you shouldn't be in the civil courts because you're part of the religion and we...
No, we're saying that the dispute, at the core of your dispute, what I'm saying is, at least in that case, what I'm saying is the core of your dispute involves really essential church policy. And since it does, the review of church policy is not subject to your civil courts. It's subject to an ecclesiastical court, and only that, because we, in essence, we answer to God. We don't answer to anyone else, right? That's the whole notion behind part of this. If we've done wrong, you take your remedy there and expect that they're going to make it right.
God's going to make it right?
God or his agents who sit in the church. And by the way, I was just looking on the way up. I mean, it's not just the Catholic Church, obviously. The Episcopalian Church, Mormons, Judaism has...
Sharia law?
Absolutely, and there's various, we could go through all the various disputes that might end up there, but there's and by the way, if we were creating the Church of Mike, no really, right, I would create an ecclesiastical system. I would create this hierarchy so that your appeals process goes internally through the Church of Mike, and you can't then sue me in your civil courts for what I do.
Well, even if we did go through your system, we'd lose anyway, because you're just that good.
Well, no, you're gonna lose anyway, aren't you? I mean, let's be honest. Why? If I can set it up so that the First Amendment provides these layers of protection, I'm likely going to do that. So would the Church of Mike then really be able to have like multiple wives? You know, and some of these cults do that type of thing with the younger brides and all the rest of it?
No.
Huh?
No, it's the same thing with Sharia law. I mean, we will not, if it contradicts our public policy or our beliefs, we're not going to, our federal laws and state laws will supersede those.
Okay, so you can't have multiple wives.
Right.
But how much less than that can we go? So I just don't marry them. I can impregnate 30 women and have 100 kids, and as long as I don't marry any of them, I'm good. I guess I'm good In or outside of church with that? Right?
Well, I mean, it depends, hopefully you take care of them.
Huh?
We can go after you if you don't support them, if you know, but no one can stop you from fathering as many children as you desire. That's not illegal. It might be a little immoral, but not.
Well, it's not immoral with the Church of Mike. It is.
It's one of the 6 pillars.
But so that's right. Help me out with my $3,000, my claim for $3,000. Are we not going to court? Are you saying that is a church matter, or because by the way, I assume you're aware, there's a lot of these occupation cases now. So Fortin wasn't the last word on it, even though it was 1994, so it was 18 years ago. There's a number of churches presently that the Catholic Church wants to close that are being occupied by various parishioners with the expectation that they're going to at least try to pursue it all the way to Rome if necessary to keep the church open.
I was just going to say that I don't really think that there was an oral contract because there wasn't mutual consideration between both parties, and basically you're giving a gift on the condition that it's going to be used for something else, but there wasn't.
How is it not mutual consideration? If enough people pledge the $3,000, we'll build the addition.
But you haven't given up anything. Like
I
you're
give up
just,
$3,000.
No,
And they're-
the church.
Yes, they're doing the building mill.
But they're not doing.
But
it.
now
They're
they've said
saying
no.
they're going
That's
to.
But there's no sort of a promissory estoppel or something along those lines? If you do this, we'll do that. So I did this, and now they say, no, change my mind. Well, okay, so give me my $3,000 back, and they say, no, we're going to use it for something else.
If it's a gift, then yeah.
But is it a gift? I thought, so when the guy comes to pave my driveway, and he says $3,000 to pave your driveway, and I say, okay, and I give him the $3,000, and he doesn't pay the driveway, he can say,
Yeah,
oh,
but
it's a
you
gift.
own the driveway, you don't
Huh?
own the church.
What?
I said, you have claim to the driveway, you don't have any claim to the church just waiting that they were gonna build.
So I can't trust their promises? I can't trust the...
Well, that's your, can't trust religion, I mean.
It's your religion.
No, is that so you can't trust the people you go to for spiritual guidance to do what they say they're going to do? And you're all looking like, no. No, that's the way that works too? I can trust... I can trust the guy who comes in the pickup truck from Maine to fix my driveway more than I can trust my parish priest who I confide my sins to. That's what you're saying?
Well, where I come from, that's actually standard.
What do you mean by that?
Well, I mean, there's just some people in my religious community who I wouldn't trust with a potato gun. But, I mean, you know, literally the people that come in and want to pave my driveway, I would trust them more than the clerics that in my community we deal with, to be honest with you.
And what religion?
We're being recorded.
Well, no, legitimate point. Go ahead.
Do you see this more in a hierarchical structure versus the congregational structure? Because in the congregational structure, it's people agreeing upon what's going to happen, and that's why you see more in the hierarchical structure, because they have that defense to do that. So it's almost, you know, you shouldn't expect it, as if you were saying you should not expect it, but I mean, obviously, I mean, it happens, and that's their cover for it, is that structure that you're going to have to go through the church, and it's going to have to be dealt with them versus taking it civilly. So I mean, that's how they protect
Okay,
it.
so slow it down. So if the structure is such that it's congregational, then there isn't this same level of protection with respect to the First Amendment, because that court system of review doesn't exist, right?
That's correct.
Okay, go ahead, Laura.
I was just gonna say, it's two completely different things. Like paying for a service, like paying to your driveway redone, and then giving a gift to an organization. You can't even lump them together. Like,
See, I'm not quite sure how automatically you guys qualify that as a gift.
It's not yours.
because it's your.
Well, the $3,000 was mine.
Right, but the church that they're building is
You're
not.
not getting anything for the $3,000.
You're not, like,
Theoretically.
hiring
I'm getting the value of us being able to worship together and to feel good and to come together as a community. That is what I'm paying for. That's what I was promised we would get. how is that not of any value? Salvation. No value to you at all? I mean,
It's not tangible.
That's different than giving your money to
well, but there are a lot of things aren't necessarily tangible that you pay for, are they? So you go to an amusement park. When you're done, what do you have left that's tangible? No, I mean.
We usually, I mean, in this case, there was absolutely nothing. There was nothing in writing. You simply put your money into the
I can show you writings where in the bulletin they said, "Come on now, we need more people to pledge
but
this."
no one signed it. It goes back to a statute of frauds argument as well. I think for real estate that you should definitely put something in
And what
writing.
happened to Sullivan versus Rooney? Okay, so now, and I know we're coming back to the notion of the statute of frauds and Judge Young's decision as well in Nessarella versus Peck, which is that the right? Did I cite that correctly? Yeah, Nessarella versus Peck, which I have problems with that too. But so the bottom line, your advice is no. You've made a gift, and there's no recovery we can have. And if you've got any complaint, you need to file something with the ecclesiastical court because it's some type of church matter.
Yeah, between the gift and the church, I think it's a really it's a really tough case because of the hierarchical structure and the notion of the gift. Between those two there, it's a very uphill battle.
Go ahead.
I wasn't saying because it's a gift that you should have to go through the church.
Right, you're saying it's a gift you've got nothing.
There's no, I'm saying it's a
Oh.
contract, and you give them this gift with the promise that they're going to do something with it. And if they don't do that, then you should be able to sue for their misappropriating your money.
Well, see, the only thing I have a problem with then is the expression that it's a gift, because a gift sort of indicates that there should be no ties with it. It is a donation with the expectation that, just as you pointed out earlier, the donation with the expectation that what was promised would be done would be done. So, and that's why I guess I'm quarreling with the notion of gift, because if I give him something, what he chooses to do with it is his, and that's why I'm not crazy about
Then
that.
isn't it fraud if like you donate, like say like when they have like the Jimmy Fund, like if there's people going around saying we're taking money from the Jimmy Fund, but it's really not going to the Jimmy Fund.
Well, but that it is fraud, isn't it? And that's why I'm wondering why, if others did it, like you all laughed when I said Church of Mike, but Church of Mike was doing this. My guess is you would be having no problem suing Church of Mike for fraud and 93A violations. But or no, you say no, we would cover the Church of Mike in the same way we'll cover the Catholic Church and the Episcopalian Church and any other religious entity. Church of Mike falls into that as well. Church of Satan, right?
I mean, if it's an organization that establishes its own rules and if it's allowed to do so, then yeah.
If it's got this internal structure of dispute resolution, right? So what's the matter with Church of Satan over here?
And Church of Mike?
Church of Mike and Church of Satan, right? We have
I
the.
don't think that's established religion.
Well, it's not established till we do.
Catholic Church and
Huh?
some things like that.
But they all had to start somewhere. No, really, right? If we could take a ride downtown here, and I could show you a whole bunch of little storefront churches, right? So, as long as it appears to me, if I read this, if I were advising a church, as long as you have a system of internal dispute resolution that has a system of appeals, the likelihood is we can keep you bottled up for quite a while. Go ahead.
I was just wondering if they kept the property in their name, if the pastor had obviously the Roman Catholic Church.
Was the money segregated or?
Yeah, if you could sue the person individually, that might be different. But I don't think they would keep the property in an individual's name.
Probably not. Well, go ahead.
I just don't think you can enforce just an empty promise. You know what I mean? Like, I understand it maybe.
Why is that empty?
Because they haven't given up, the church hasn't given anything up. And I just feel like in contracts we learned that it had to be mutual consideration. So you're giving everything up by giving up the $3,000 in hopes of getting something in return, but they haven't put a down payment, or they haven't, given you any piece of writing saying, like, we're going to get.
We can't have mutual promises which would act as consideration. I promise to do 3 and you promise to do
Their
this.
consideration was the promise to build the wing, and your consideration was your $3,000 that you
It's $3
lost.
grand. Right. Go ahead, Bob.
So what if it was the same situation and someone came around during church saying, okay, we're going to donate all this money today to the Red Cross.
Right.
So let me take your money. You
may be criminal, right? And it certainly sounds like fraud.
But what they could argue is that it still has to do with, they're donating it because of their faith. So that's the argument. It's not that you don't have a case, but you have to try it within the confines of the church. They're the ones who will be the judge.
We were collecting it for the new wing, but we decided to give it to Haiti in view of the disaster to Haiti. We think it's more appropriate with our mission.
And they can do that.
And they can do that, consistent with their mission. Go ahead.
Right.
Even the Church of Mike and Church of Saint.
Well, I think these are cults, but if you say so.
I'm not saying so. I'm asking you because I heard you say, "Oh no." That's what I heard over on the side. And it can't just be religions you favor that you're going to give this protection to, right?
What I want to say is that I think our society holds religion, established religion, to a higher standard. And I think like Karen is saying, when the church is asked for something and you decide to donate, you put in your faith into your church, knowing that your church is doing what they're doing for your best interest as a congregation. So even if they don't use the money to build a wing, we know the money is going towards God's purpose. So, I mean.
Well, so you're saying I have no cause of that, because so you're saying in essence what at least part of the argument is that it's God's will to do whatever the money they want with the money, and you don't have any recourse.
I think the church should be able to resolve those issues on their own, and the church should be able to handle it on its own, because the church is.
So I'm out my $3,000, and they can do whatever they want with it, just right?
But it's whatever is being done is for whatever God's purpose that we deem religion to have.
God's purpose as determined to be what the bishop now says.
I guess.
What if the
Or we
bishop
charge
was the
them as
fox
the
was with the
agents.
$3,000?
The bishop wants to take a vacation.
Well, it's God's purpose, I guess, so.
I don't understand how.
I was just gonna say, I understand the concept of giving it due to your faith to the church, but couldn't you argue that there was a condition upon which you gave that money? This is, and then you can further argue, if it wasn't for that purpose, I didn't have the money, so I wasn't gonna give it. But because it's for that specific purpose, I went out and I worked extra because I care about that particular reason.
Well, but isn't that precisely where we started a little while ago, is that when some of these larger donations, that's precisely what it is. I want a building named after me, or I want named after my mother, or whoever it is, and I expect you to build that wing, and I expect it to be named, or whatever. And if that promise isn't carried out, then in a lot of these cases, especially with the larger gifts, you do see suits saying, I really don't care how you ended up choosing to spend it. You didn't do what you promised me you would do it when you took it. I want the donation back. I'll give it to some other institution that will do what we said. The problem comes in here when it is in fact the church. We get these First Amendment and subject matter jurisdiction issues that raise its head, saying, well, we've got to have a separation between the church and the state, and in fact, it's incorporated within this dispute resolution notion.
I just think that it's the court running away from something. They don't want to get dirty with the whole religion thing. Because if you look at it strictly as these are two people and one said something and he was going to do something and he chose not to, then you should be able to sue. It shouldn't matter that it has to do, the underlying reason was in a church. That shouldn't matter.
Yeah, I mean, it's not an issue of faith, it's an issue of money.
But you, and I understand the arguments, but tell me about the notion of the First Amendment and subject matter jurisdiction, because we look at these cases and they seem to make a pretty clear distinction that if this is what we'll just call generally a church matter, that you're stuck with a church resolution of it, a church court, not anything else. Mike, and then I'll come down.
One way to circumvent that, could you if my clients were ready to give $10 million away, I'd have them sign a contract with the person that they were giving it to, saying that in recourse of you not doing this, that you're being dragged, you're allowing yourself to be put into civil court.
Oh, but I agree with you, but I don't even know whether such an agreement would be enforceable, because if I wanted to breach the agreement, I'd still argue, it's still not enforceable. It's weakened, because if it's subject matter jurisdiction, it doesn't make a difference what we say. It's a question of whether the courts feel it still falls within the First Amendment issue, and my guess is there'd be people like the owner and others who say, I don't need to do that with my church. I trust my church.
But this doesn't make sense.
Go ahead.
Just because they're a religious organization, they're covered by the First Amendment, they're immune to the laws of everybody everybody else's.
Did you read the
Yeah.
case? No, seriously, that is the point about making sure you should look at these, because there's actually more matters that fall within this than you'd think, and there are other things that are going to come up over time. I had a client, she needed a get, which they were Orthodox Jews, and in order for her to be able to obtain a divorce, the process works that her husband has to agree to give it to her, or she can't get divorced, and therefore, in essence, she would be, I guess, in essence, equivalent to excommunicated from her religion if she chose otherwise, or certainly wouldn't be in good standing. And so the question is, well, how do we get the get? And you'd have to go to rabbinical court to try and obtain that as part of the process as well. So I mean, there's a lot of different things where these issues start to come into play, that you at least have to be aware of them, and even some of them even more so now, where some of these issues about who gets to direct whether a church closes or stays open or not, which those cases are pretty much being lost, as you see in Fortin as well. I said I'd come back to Karen next.
Two things. The first thing is, I think we've become such a secular society that it's hard for us to accept the fact that religion or a church or a synagogue or a mosque has that First Amendment right to keep their religion separate and to do under the auspices of their religion what they choose. It's hard. I mean, it's hard to grasp that. The second thing is, look what's happening right now. The Supreme Court is wrestling with the health care bill, and that's so much a part of the argument right now, that the church, you know, the First Amendment right of the church not to participate in parts of this health care bill because it affects their religious belief. You know, so it's really so relevant. But again, it goes back to our secularism, as you know, we're not as religious as people once were, or even we don't even consider it, you know.
And if you think the hypothetical is that far-fetched, I mean, Fortin is pretty close, right? They raise enough money, we'll keep your parish open. They raise pledges for $600,000, and he says, you know what, I'm going to merge them anyway. Which again, I think, especially for older people, this is quite traumatic to lose their connection like that. So I mean, if you're going to give the church the ability, or at least to the process as well, unless they can use, as the case says, neutral principles of law to resolve the dispute. And we'll talk a little bit about that in a minute. Go ahead. You have the floor.
Yeah, well, you were just coming right to where I was going to speak on it. You know, when you're dealing with a situation where you've got one single person making a multi-million-dollar donation in return for his name on the building, you know, that's one thing, and you can handle that without imposing too deeply on the church's principles and so forth. It's a legal matter. But when you're dealing with the properties and you know, the organization and the decision process within the church itself, and as it says in that same area, if the dispute can be resolved without inquiry into matters of religious doctrine or polity. And so the point is that you get these property disputes with closing churches, for example, and now the church is kind of getting a little bit inside the church itself. It's starting to pick apart its organizational principles, its people. You know, doesn't mean you don't have a case, but it needs to go to the right tribunal, and that needs to be the church. And you need to hope that the organization leaders that would be the fact finders in all of this would do it appropriately. It wouldn't necessarily happen, but you know, you can only hope, and that's all you got. But the court's not going to come in and start marking stuff up for evidence. It's like, I think you'd be just as appalled if you saw some of the things that they would stick in their noses.
The language that Scott read is at 786 of the original decision, where what the language in the case says that that the most notable departure from the traditional notion that civil courts ought not resolve church property disputes came in Jones versus Wolf, which is a 79 case. It says that states are constitutionally entitled to adopt, quote, neutral principles of law to resolve church property disputes. Thus, if the dispute can be resolved without inquiry into matters of religious doctrine or polity, the court may examine such sources as statutory provisions governing the holding of property by religious corporations, the constitution and bylaws of the religious organizations involved, especially insofar as they pertain to the ownership and control of the property, and C, the deeds to the property in question. And if the fact they can't apply these neutral principles of law, and it is this church matter, then the fact is that they shouldn't be touching it under the First Amendment, because they do get this pass with respect to policy that they're entitled to create. On 789 of the original decision, it also gives us that definition of resulting trust that we talked about the other day. A resulting trust in real estate arises, and this is what they do with this case, is they try to analyze it to say, well, where would the claim be if we just look without trying to touch on the religious aspects of the problem? Where would their claim be? Do they potentially have a constructive trust claim? Do they have a resulting trust claim? And resulting trust is pretty easy to dispose of, which says a resulting trust in real estate arises where one party furnishes the consideration to purchase the property, not intending a gift or advancement, yet title is taken in the name of another. As a result, the trust must arise, if at all, at the time of the execution of the deed. I'm wondering how, with respect to these alleged neutral principles of law, we don't have some better argument with respect to a constructive trust. They asked us to raise the money. We raised $1 million initially. We then raised more money to try and pledge to keep the property in good repair. It says, and tell me why this wouldn't work maybe in my situation as well, at least some portion of it, and I'm not sure what. A constructive trust is imposed in order to avoid the unjust enrichment of one party at the expense of another, where legal title to the property is obtained, A, by fraud, B, in violation of a fiduciary relationship, or C, where information confidentially given, and I'm not saying it's that. Isn't it by fraud or in violation of a fiduciary relationship?
But there's no unjust enrichment.
Well, they got my $3,000.
But they put it back into the church.
Right, exactly.
But that was not.
You're benefiting from what they used the money for.
What?
You're benefiting.
No, I'm not. I'm
Yes,
not
you
benefiting. They pay claims, or they send it to Haiti. I don't benefit from that.
You're still getting salvation.
Yeah, you're still getting salvation. There's no value in that.
There's value in that, but that wasn't what you promised you'd do with it. How are you not unjustly enriched by taking my $3,000 and doing with it something other than what you promised? By the way, it's do I have a fiduciary relationship with my clergy members?
With your priest, but not with the
do you think?
diocese.
Huh?
I think you do with your individual pastor or priest or whatever, but I don't necessarily think that the diocese of
What's
Boston
fiduciary relationship?
has any
Position of
fiduciary
trust.
duty to you.
You can trust those that provide that spiritual guidance to you? No.
The diocese as a corporation is not providing guidance to you.
The bishop doesn't? He's not the leader of the flock?
diocese.
Huh?
He is not the diocese.
Yeah, but he is,
But
isn't
he's
he?
not. He is a representative of the diocese.
Well, who's the diocese? The building?
Like this Massachusetts School of Law at Andover, Inc.
But
Like, you know what I mean? That's not.
But
What?
that's represented by the people who run Massachusetts School of Law at Andover, Inc. Right?
Right.
So that's the bishop in the church's case, isn't it? Isn't there a fiduciary relationship there? Because that's all I've got to do, right? It's either fraud or a violation of a fiduciary relationship. You promised, you took my $3,000. How is that not unjust enrichment? Go ahead.
How is it not a resulting trust either, since the people are the ones furnishing the consideration to purchase the property?
At least initially. The $1 million initially that was raised to build a church. Why not? Well, because it says not intending a gift or advancement.
Right, you're saying it's not a gift or
I'm saying mine isn't, but I've been hearing gift an awful lot, and that's why I'm wondering. It says not intending a gift or.
But if it's not a gift, it's certainly an advancement then to
not
do.
an advancement if you're like literally paying the whole thing, not giving them an advancement, expecting them to pay you back.
Well, you're giving them the money to build the thing, and you're advancing that.
Right,
to
but
build up
doesn't
wing.
an advancement mean you'd have to give the money back? Like, I'm giving the money up front and then you're paying me back?
I don't know,
pay
how
them.
is it not if it's not a gift, how is it not an advancement?
Because.
That's what your argument is. It's either
Right, I don't
a
think it's
gift,
either.
advancement, or loan.
I don't think it's either.
I don't
Right?
tell-
Aren't you paying for it?
Huh?
Aren't you buying it? You're giving them the money to purchase the
To
place.
build, to purchase the additionals.
Right.
You're
To say
advancing
it's-
them.
Yeah, say it's like an extra church or something.
And he's saying that's just an advancement.
I think a lot of it too depends on, like, people are talking about public policy and, you know, it depends on what the public, I mean, you, like, obviously in one room here, like, a lot of people are viewing this as a gift, so I think society as a whole, if they view a donation to your church as a gift that the church can do for your salvation, then you're, you know, the court's gonna uphold that sort of thinking. It's the same thing as churches that run hospitals. You know, they used to be able to not have to give Plan B for, you know, the morning after pill, and now society expects it's open. If your hospital's open to the public in general to get treatment, then they have to, even though it's against their faith, their hospital has to offer these abortion pills. So I think it just depends on what the expectation of society as a whole, and I think society still is viewing a gift to your church, money donated to your church, as a gift for them to do what they want.
And my question is that because you're cutting, you know, these long organized traditional churches slack, because you're simply saying it's a gift, or are you saying, no, Professor, if it was the Church of Mike or the Church of the Psychic Healing Power, we'd be doing the same thing?
They would have to do the same thing. I don't agree
You
with that.
would honestly come to the same decision. So over the last year, the Church of the Psychic Healing Power has taken $100,000 of my mother's money because they're going to locate my dead father for her so she can talk. And I say, well, it's a gift. You're really going to stick with me? You're going to say it's a gift still, or you're going to say, whoa?
Well, the courts have to treat religions the same. I mean, Jehovah's Witnesses used to be treated like a cult, and now they're treated as a religion. So
it does. Go ahead, John.
I think, we've been talking about the Roman Catholic Church. I think that people are learning to get a lot more, I don't know myself, but I think they have to get more, they're being less trusting of the clergy. And so the thing to do there is you don't put it in the collection box because everybody knows that they can make a decision on what to do with it then. You have to put it in, maybe into a community, kind of a trust or something, and say, if you want us to raise money for this,
Break ground.
we're gonna give it to this person and you can accept it on those terms.
Would it matter to you if on that $1,000 check each year it said new wing? What if I did have? Is that what you're seeing? We pass the hat. If it goes in there, whatever they do with that, you shouldn't expect much. But what if? Would that matter to you if there's a separate $1,000 check every year that says new wing, and they took each of those 3 new wing checks, cashed it. Now they're saying you're out of luck.
I think, yes, that would help you. And I'm also having trouble seeing it as a gift with your specific scenario. And this is why, and I think John touched upon this. So in the beginning, in your scenario, people were donating money anyway, just, the
Right.
daily donations. But then the priest had to add on to that and say, we would like additional money.
Right.
So isn't there a difference between that initial gift donation and then this new one that is upon the condition that it's going to be for that?
That's what I would envision it, but I can understand the arguments. And I guess I was really wondering whether, and I think I'm getting the feel that, well, if you got any chance, you're going to a church court. Do we agree with that? Is that what the sentiment is? Because it seems like most of you think you've got zero chance at all. But if we've got a chance, is this an ecclesiastical matter that has to go to that court as opposed to a civil court? Or
I think you have a better chance if it was promised to the church in general and everyone that donated went and said, listen, this is what our money was supposed to go for, and it's not, versus one individual who steps forward
But it's gonna take someone to stand up first, right? You know, and by the way, my guess is that's not gonna necessarily be easy either. You know, risking hellfire, right? Right? Who wants to? A lot of people don't want to come forward. Good luck.
Yeah, I think if you have even something written in the memo line saying, oh, to the new wing, and then you go to the church, go through their procedure, and say, I wanted to go to this, they say no, then I think you have enough reason to go to court. And I mean, that seems like enough right there to me.
Well, court as opposed to church court.
Yeah, I think you should go there, and if you have any kind of.
I would agree with you, but I don't think it's going to happen that way, especially in Massachusetts when they haven't adopted. Massachusetts hasn't adopted the neutral policies as other jurisdictions has. So I think it's just in this state, especially, it's even that more difficult. So I mean, I would expect that too, but unfortunately, I think they're going to claim the First Amendment immunity or charitable immunity, whatever immunity that they'll claim, and it will work under the First Amendment.
That the argument being that you have to pursue this within the internal structure.
Through their means, through their.
If you put something on the memo of a check, wouldn't that satisfy the statute of frauds?
And then, because then it's endorsed on the back. Well, I think we get back. We must be getting more comfortable with the statute of frauds at some point. There is some writing that evidences what the, agreement was. This let's. I mean, you've read it. Think about it. It's not as clear cut, and I'm going to leave it like this because it's not that clear cut. But I think it's a very interesting case. At the end of the day, they are in fact out of luck on this. But there's others. There's cases in Braintree. There's another one, a more recent one out in Worcester. There's a lot of these church closing cases that are struggling with the same issues. And there are some that are actually proceeding through ecclesiastical courts. One of them was won at least in part through one of the ecclesiastical processes. But I think you almost have to win occasionally so that it looks like there is a process there that has some merit. But I think it might have been the one in Braintree, was won by going through that. Because Nessarella versus Peck, now this has nothing to do with churches, but this one bothers me a little bit as well. He did take advantage of information provided to him confidentially, didn't he? I mean, at the end of the day, the judge doesn't impose a constructive trust, doesn't impose a resulting trust. But how come he's not a faithless agent? Because if we look at this one, they seem to be working together. Not seem to be, they are, right? Peck asked Nessarella to act as his straw in order to get the property. Peck agreed to act as the straw because there was some bad blood between them. And then he asked him about it. He said, "Oh, I'm working on it," and then takes it for his own. And Nessarella files a complaint seeking specific performance. And then we have some problems with the findings of fact and conclusions of law as Judge Young moves from the Superior Court in Massachusetts to the Federal District Court. Judge Young is very well regarded. This is not his finest moment because, as you see in the case, the findings of fact and conclusions of law weren't done till well after the case, well after he had actually moved on to the federal court and the like. So it really is a procedural mess up. But let's take a look at the claims here. What's this phrase? A second Superior Court judge ordered the findings of fact and conclusions of law to be entered nunc pro tunc to May 23rd, 1985. Now for that, very good. Oh, motions, is that? You know Latin.
We're learning.
Who do you have for motions? Who do you have for motions?
Cuddy, we have Cuddy.
Very good. What's it mean? Now for that, huh?
Yeah.
No, but what's it mean though? Why do we enter an order non pro tunc?
Because you want it to be retroactive to that time.
You're Cuddy too, I take it.
Yes.
Very good. And that's in fact true. You do it more often than you think to correct gaps like this. And so you ask that the order be entered non pro tunc now for them. And what you're trying to do is fix the problem that exists from an earlier time. Have you enjoyed that class?
Very much. He's told us that if we know that and use it in court, the judge will be very impressed. So you know. Right.
You'd be surprised that it's not frequently used, but when you need it, you need it, and he is in fact correct that it helps to fix problems, and it's important to understand that the court can actually enter the order in essence with that title on it. In essence, it doesn't really make it retroactive, but it appears to make it retroactive to that date to fix the procedural flaw that exists, because obviously the findings of fact and superior and conclusions of law should have been entered well before this time period here. And of course, Judge Young moves on, and he's left us with this mess. And of course, the loser says, well, what the heck is this? Go ahead.
Nostrella had no proof. I mean, when he asked the gentleman to purchase a property, he didn't even put up any finance or anything. So then for him to turn around and sue the gentleman, saying that the guy bought the property and then created some kind of trust, I think itself is fraudulent. I think the fraud, I believe the fraud itself was committed on his behalf. Because how could he expect somebody to buy a property as a straw buyer? Isn't that a fraudulent transaction in itself?
Well, is it? Because I could see this happening. I could see I've got a dispute with my neighbor, and I said, listen, let's just be done with this. You're sell it to me, and we won't have this fight going on any longer. And he says, I prefer to lose it to the GD Bank than ever sell it to you. And trust me, I've handled a lot of neighbor disputes between individuals, businesses, and the like, and there will be people that's absolutely the way this would go down. But on the other hand, if I send you over there and say, geez, I'd really love to buy your house or buy your farm, whatever it is, and the price is right, you're not going to quarrel at all with giving it to her, selling it to her for a fair price, as opposed to either not selling it all to me or charging me a significant premium. And that's the other part. Sometimes we use straws is, if you know it's Walmart that now wants your property because they own the other 15 acres behind your house, you're very likely to figure out, oh, this is my chance to cash in. Where if you think it's, Walter Matthews buying your house, you're gonna, and so it's not uncommon to use a straw, and sometimes for more legitimate reasons. Sometimes it's just because people hate each other. So I'm not so sure it's so bad. How are you so willing to excuse what he did, though? So I go to you and say, Fiona, will you buy this property for me? If he wants 200 grand, here's 200 grand, you go get it. And you know yourself it's worth 250. So you say, well, I'll see what I can do, and you go buy it for yourself for 2 and say, well, I'm still working on it, Mike. How is that not? How is that not taking advantage of confidential information I provided to you? Go ahead.
Yeah, I mean, I had a problem with this case. I thought it was really unfair. I mean, as Bravo lived up to his end of the agreement, he even put an assisting Peck in getting the Hayward farm, put $11,000 of his own money up front, took title, and then turned it over. So
did exactly what he was asked to do.
He lived up to his end of the bargain, so I had a problem because he didn't get the same.
Well, it doesn't fair. So
it's not fair, but I guess a lot of things in life. The guy, you gave the guy information. He used it for his benefit. I mean, I think don't you expect sometimes in life that people would
It's another important lesson to have everything in writing too. Again, it's another important lesson to make sure everything's in writing.
He was.
Right, they were related. This was his son-in-law.
Son-in-law, yeah.
Well, but that's a lesson to take home, even with family. Everything gets reduced to writing, so it's clear as to what our maybe I don't want to say illegal. I don't know what kind of, I don't know what modifier I'll put on it. Go ahead. Shifties. Shifty deal is reduced to right. Go ahead, John.
Isn't it a partnership? I mean, for a purpose?
But again, where's the, I think, I would have no problem seeing it that way. Where's the writing that indicates it? Because there is performance on both parts, it would appear to me. It's that you buy this from me and then we'll swap it around, we'll be good. And he does precisely what was asked of him and then gets beaten for it. And the court says, no, we're not gonna go out of our way. And again, when we start with Sullivan versus Rooney and we see the court actually go out of their way to try and avoid the statute of frauds, it seems kind of funny here that we're not. Because this whole agreement could be done within a year, but it's still the agreement concerning real estate. Go ahead.
I was just going to say that it's similar to the church situation because it was just an oral promise that he just refused to carry out. So, I mean, there's nothing you can do about it. That's too bad, but he didn't pay him money.
Well, wait, why can't it be, though, the constructive trust? Because the language was part 3 here, at the minimum.
It wasn't fraud, and apparently there was no fiduciary relationship.
Well, wait, though, it says, C, where information confidentially given or acquired is used to the advantage of the recipient at the expense of the one who disclosed the information. Right, that's the third part of constructive trust. Because I'm not sure how that isn't satisfied here. I gave you confidential information about the sale of the real estate. Well, I think it was, wasn't it? You took it for your benefit. No, where information confidentially given or acquired is used to the advantage of the recipient at the expense of the one who disclosed the information. I don't know how Judge Young can so easily reject that shouldn't be a constructive trust. Oh, is it just, at least in part, Fiona's point about, geez, I don't see where either of these guys has completely clean hands and I'm unwilling to look for relief. Except by taking that tack, one guy gets everything and the other guy gets really nothing out of the process.
How was it confidential?
Say what?
Where was it?
No, he gave it to him confidentially. It doesn't have to be confidential information. He only has to provide him the information confidentially.
But I think Fiona is right when she talks, there was no, the judge talks about illusory evidence. There was nothing that he could point to, and he probably just didn't like Massarella.
Well, what do you mean there's nothing? Because it was pointed out that, well, he did buy it, he bought the other land, and then he turned it over. I mean, there's some evidence that there was
a deal there.
A deal.
The prior deal.
Huh?
Not this deal, not that.
Well, but the plaintiff's argument is, well, that was part of this deal. That we would, in essence, serve as each other's straws for these transactions.
The defendant says, no, he wanted to prove it.
And he's got no writing to prove it.
That's right.
So he's out of line.
And I seem more credible than him.
Well, see, I thought the court took it more clearly, not necessarily on the issue of credibility, but on the basis of, well, let me just apply the law in a black letter fashion here and see how you satisfy it. And I think the court, as my problem started out with the first case in the sequence, is I'm not sure you can get past the statute of frauds. Right? I mean, if we look at what we all sort of take as a core element of contract law, how do I get past this? There's nothing in writing that evidences these fairly significant transactions. I think there's conduct, but I think the court has the problem as they apply the law. Because I do see him as a faithless agent, but the court says, and this is on 763 in the second to last paragraph, the court says there's no evidence that supports that, or neither claim has merit. Resulting trust, and I don't have a problem with it can't be a resulting trust. I have a problem with whether it could appropriately be a constructive trust. I do think that there is some level of unjust enrichment and use of information confidentially given that advantages one and disadvantages the other. So I don't think it's a resulting trust. I don't think you can show that. As it said, he didn't furnish any of the consideration. But I do worry a little more about constructive trust, but the court doesn't seem to be able to get past the whole argument about statute of frauds. And saying that, because the judge, it says the judge found that the parties contemplated that Nesrella's performance would not be completed within 1 year. The finding was warranted on the evidence. I mean, that argument, that language though also indicates the court did feel that there was some agreement to exchange these lands with each other. It just wasn't going to be completed within a year.
There was one point where he said where he would grant specific performance, even without this, under the statute of frauds, if it was so if the injury was so unconscientious injury and loss.
Mm-hmm.
So that unconscionability, I guess, that then the court would be able to overlook it, get past it.
They might be able to under the circumstances is the thing. The constructive trust, by the way, that argument is all in the paragraph before saying, you know, the family relationship alone is a fiduciary relationship. I don't see where they really take a hard look at the third aspect of the question about constructive trust and the like. And I guess I could see where fraud, which generally requires more proof, to a higher standard of proof. If you're going to claim fraud, it generally has to be shown by clear and convincing evidence, not simply the preponderance of the evidence standard. I could see where you could fall short there. I just don't see where Young tried to apply the third part of the test, which I think is more likely what he can win on if he's going to win at all. But that analysis wasn't done. And I think in part, if the findings of fact and conclusions of law had been done timely, it might have been clearer what the proper analysis that the court should have done. At the end of the day, they agree with you guys and say that there isn't enough here to support it. I gotta run to Boston, so I will see you Tuesday. Yeah, right. Want to get stuck in traffic too?
Right. Did you guys break into groups of the did you break into groups of the
Yes, we did.